Hi, everybody. This is Ladies, Lipstick, and Litigation. I'm Heidi, and we have Janess here as well. And today we're talking about a really fun topic. We will be still talking about trademarks, but we're going to be talking about trademark cases related to diamonds. So I'm going to be talking about a case related to the Harry Winston trademark. For those of you who don't know, he's like super famous in the diamond industry. And Janess will be talking about a Tiffany and Costco case. So
I enjoy that you wore Tiffany blue as an homage to my case today.
Exactly.
It's not quite Tiffany blue, but we'll pretend for today.
Of course, exactly. So Janess, would you like to get started and tell us about your case?
Sure. So this has been a long-standing battle between Tiffany's, that everyone knows and loves, and Janess would like more of, and Costco, who has a jewelry department, sells their own diamond rings, things like that. As we all know, Tiffany has a long history of using the name, signage, the color blue that we've alluded to, even some would go as far to say the packaging with the little white ribbons that goes around the little blue boxes. Tiffany sued Costco in 2015 for trademark infringement because Costco was selling rings that had a little Tiffany place card in front of it. Tiffany said that this was not only trademark infringement, but also counterfeiting, which is an interesting thing that we can come back to. The judge agreed at the trial court level that it at least constituted trademark infringement and granted them a judgment on summary judgment just for the sign that said Tiffany. Costco had presented evidence that only 6 of 3,000 customers who had purchased the ring had any sort of confusion that there is actually a cut called the Tiffany, a Tiffany cut or Tiffany design of diamonds, and that the little place card was in front of those diamonds to, in good faith, identify to the customer what kind of cut that was. The judge overlooked that evidence or did not consider that evidence and granted liability, and a jury awarded just over $8 million in damages to Tiffany's for the trademark infringement. The counterfeiting was not decided. That was going to go to trial. Later, the judge bumped that damage amount up from, I think it was 8.25 to $21 million. Costco appealed, naturally, and it actually did just get reversed, and it was sent back for a new trial. So we'll see how it goes. It looks like a pretty contentious battle, and neither side, it looks like they're going to be waning anytime soon. And I think we've seen quite a bit that Tiffany's does not back down from a fight. And it brings up an interesting question, which I think leads into your case here, as to whether or not that would have been enough. If Tiffany's wasn't Tiffany's, if I opened a jewelry store tomorrow and called it Janess's, if someone else had a sign that said the Janess cut, and that was also a cut of diamond, would it have been trademark infringement, or did Tiffany's have so much success because of the fame of Tiffany's?
Yeah, that's a really good point, Janess. And that's certainly something we'll talk about in my case. I just had a quick question for you. I have never heard of the Tiffany cut before. So is this like a specific cut of diamond that diamond connoisseurs are familiar with?
So it's a Tiffany setting, I should say, not a cut.
Got it.
But I am not aware of it. I wouldn't necessarily call myself a diamond connoisseur. I did my little shout out today, but other than that, I couldn't tell you what a Tiffany setting looks like. I couldn't tell you what most of the settings look like because I don't have enough Tiffany's in my life.
Well, hopefully we can remedy that for a future episode and get back to you on it. So my case actually involves another really famous person in the world of diamonds. This regards Harry Winston. For those of you who don't know, Harry Winston was huge in the diamond industry from the 30s all the way through the 70s. He had a couple of really catchy nicknames. He was referred to as the King of Diamonds, the Wizard of Rocks, and the Ace of Diamonds. So that's fun. Also, he bought the Great Hope diamond and donated it to the Smithsonian. And he's perhaps most known for the classic movie Gentlemen Prefer Blondes with Marilyn Monroe. There is a musical number, and there's a line in it that is, "Talk to me, Harry Winston, tell me all about it."
Would that be
So
Diamonds
literally in the
Girls
song
Best
Diamonds
Friend?
Are So super famous. So like when you think of diamonds, like Harry Winston is a name that just comes up. It's very well known. This case is interesting because Harry Winston passed away, and then various members of his family kind of tried to branch out, start their own businesses, including his son Bruce. So his son Bruce wanted to start a company called Bruce Winston Gem Company, and he filed for trademark registrations. And the Harry Winston Company fought against this very hard. And actually, the court decided that the trademark Bruce Winston was going to cause confusion with Harry Winston. It's actually a really interesting case. And so all those facts about Harry Winston we just talked about, the court really focused on. They focused on how well it was known to consumers, how well Harry Winston just is prevalent in the media. And it was interesting because Bruce, in a lot of his advertising for his own business, referred to himself as a son of Harry Winston, or that like his business was the successor to the Harry Winston business. So in kind of did himself in a little bit by reinforcing this connection with his dad's business. And it was really interesting because in this case, the court noted that even though a lot of the evidence was for the use of the trademark Harry Winston, they noted that consumers tend to shorten things or don't use whole trademarks because it's easier just to use part of a mark. And so that customers would also recognize Winston as referring to Harry Winston and the Harry Winston Jewelry Company. So even though his name was Bruce and Bruce Winston, he was not able to get a trademark registration for his name given the fame, longevity, and use of his father's trademark registrations for Harry Winston. And I checked it out on the internet. The company doesn't exist. I don't know if he came up with a new diamond company with a different name that does not involve Winston. But I thought it was a very interesting case because even though it was his name, given the rights established by his father and the fame of that mark, he was unable to come up with a successor mark, just given the connection that the public would create between the two marks.
Well, and him trying to create that connection himself probably didn't help.
It was not great for the case, I'll say that much.
So I shouldn't try to create a Winston cut of diamond, is what you're saying.
We're going to have to come up with another good name for a cut. I like the Janess.
Yeah, I'll go with it. Well, that's all we've got for today. Hopefully next time you see us, we've got a few more of our girls' best friends with us. Please tune in next time, and we hope to see you next time on Ladies, Lipstick, and Litigation.